My name is Sam Buffaloe, and I'm an attorney with the Appellate Division of the Missouri State Public Defender's Office in Columbia, Missouri.
I'm Jennifer Bukowsky. I own the Bukowsky Law Firm in Columbia, Missouri.
I'm Amy Elizabeth Lowe, and I am an assistant public defender with the Appeals and Post-Conviction Office in St. Louis.
The purpose of my job is to make sure that my clients received a fair trial. And that is what drives me to work hard for them every day, is to make sure that they got a fair trial. So sometimes, even if I lose an appeal, the client feels like they received good process from the appellate court. And that's what drives me, is to make sure that my clients received a good process and a fair shot at winning their appeal. I am most proud when an appellate court agrees with me that a past appellate court has gotten something wrong. And I've been fortunate enough to have 4 cases decided where an appellate court has agreed with me. One particular case last year, the Eastern District Court of Appeals agreed with me that a body part could not be considered a dangerous instrument. But there was a previous Western District case that had determined an elbow could be a dangerous instrument. My case involved a fist. And the Eastern District Court of Appeals agreed that a fist could not be used for armed criminal action. And I'm particularly proud of that case.
I feel privileged to be part of the appellate review process because it allows us for an opportunity to correct errors which inevitably occur at the trial court level in a manner that defends the constitutional rights not only of that individual client but of all Missourians. My approach is thorough and time-consuming with the objective to win on behalf of my clients for the cases that I choose to take on, that I feel have merit, where I feel that there's been a trial court error that needs to be corrected, to not be afraid to be different and creative about the way about which I seek that result to correct that error for my client. And so I use different strategies, a lot of strategies that I use in trial courts as well as an advocate in appellate courts. I've pasted videos into pleadings. I use photographs, I use color, much to the chagrin of certain court clerks. But I'm really trying to bring technology and some of the techniques that we're using at the trial court level into the appellate court arena. And so, with the objective, of course, to be an advocate for my client and to correct an injustice when one has occurred.
As much as I love the academics, I love the law. I'm an obsessive opinion reader. I read them all the minute they come out. As much as they drive me, and as much as if you took them away from me, I would curl into a small ball and be a mess. It's the people that really matter. Every one of my clients, although some of them have done or have been accused of doing extraordinarily unsympathetic things, are people. And they're the people that we forget about because they're easy to forget about. They are in a small box, often for a very long time, outside of society. And making sure that they at least get some basic level of review for why they're in there matters so much. Little issues, little failures, take away people's lives in the criminal justice business. There are people who have been in prison longer than I've been alive, more or less in legal practice, who are still trying to sort out through these fascinating academic problems that ruined their lives, their families. It cascades outwards. Each time I get somebody some relief, and sometimes it's a pittance of little relief, a year off, return for a proper sentencing hearing, that is a victory that matters. Every time somebody feels like they actually got the issues in their case heard, it might not be a win, but sometimes it matters just as much.
I think it's important not only to read new cases as they are decided, But also, I would recommend going on to CaseNet, and if a case interests you, actually reading the briefs that were filed in the case, and to see what arguments those attorneys made, and to look at the motions that were filed. A lot of times there are things that happen in an appeal that don't come across in the opinion that you can get from looking at the docket sheets and reading what was filed. So if you have time to do that in a case, I would really recommend really digging into CaseNet.
My advice would be that it's hard to say at the outset how much work an appeal is going to be because you don't see all the issues right away. I don't think anyone can. So however long you think it's going to take you to do it, multiply that by at least 10 and know that going in. And because it just requires such an extraordinary amount of time and resources, if you do have the luxury of being able to choose which cases that you take on, just take on the ones that you believe in, the ones that you're fighting because you believe in the case and that you believe the law should be changed and that an error should be corrected or a verdict should be, defended, whichever the case may be.
Don't be afraid to make the argument that seems a little crazy the first time you go through. A lot of times we're tempted to stay with safe claims, the claims that we've used before, the claims that we know. And the reason those claims are safe is they've been done a million times before and they've lost every time, or nearly every time. Pushing the envelope is okay. Do it within the realm of sanity, do it within the realm of the rules of ethics, but watch the legal journals, watch the courts, see what's moving and changing, and don't be afraid to raise something different or difficult just because you're new. No, you're not proven, but there's no way to do that other than to run with it.